Today, we are going to talk to you about some quirks and unusual aspects about the handling of Canadian designations under the Madrid Protocol. Next slide, please. I will be presenting with Nora Labance. Nora is a trademark lawyer and trademark agent in our Ottawa office. Before she became a trademark agent, she wrote the qualifying examination and was #1 in the entire country. So we know that Nora is very capable. Nora handles all areas of prosecution, as will become obvious during today's talk. Nora also handles oppositions, cancellation proceedings, and any and all aspects of Canadian trademark law and practice. My name is Philip Lappin. I'm a principal also in the Ottawa office of Smart & Biggar. I've been practicing for about 30 years, and I also handle all areas of trademark law and practice. Next slide, please. I'm sure all of you who are attending know that we are Smart & Biggar, and we just became a little smarter and a little bigger in the last 2 weeks. You may have heard some exciting news. We just merged with a terrific firm right out in Maybe a couple of weeks ago. So each of our firms is about 130 years old. And so now we have about 125 lawyers, trademark agents, and patent agents. We handle all areas of trademark law and practice, patents, all areas of law and practice. We have experts in any field you might want to deal with. And on the litigation side, we have one of the most well-respected teams in Canada with among the highest success rates. If you look at any IP surveys relating to Canada, we're always at or near the top in any category. Next slide, please. So this is what we're going to talk about today. And I should tell you that we are happy to answer any questions you have. Please feel free to ask questions. You're all on mute. But you can send us questions by text by clicking on the Q&A tab, which you should see at the bottom of your Zoom window. We'll answer questions at the end, but please don't wait until the end to ask your questions. Whenever a question pops into your head, please type it right away and we'll be sure to get to it. If for whatever reason we don't have time to get to your question during the talk, we will email you the answer. Please do not ask us questions in the chat box. If you have technical questions, you can ask them there and someone behind the scenes will answer them. But Nora and I will probably ignore any questions that appear in the chat box. So what will we talk about today? Well, we're going to start talking about correspondence issues. And now you're saying to yourself, that is not a very sexy topic. Well, in Canada, because of the quirks that you're going to hear about, it is quite sexy. We're also going to talk about provisional refusals, of course. For those of you who've seen provisional refusals around the world, you might expect to understand them. If you see a Canadian provisional refusal, you may or may not understand them because they can be quite confusing. So we're hoping to help you interpret those provisional refusals, at least somewhat. Amending a Canadian designation. Once again, there are many quirks of Canadian practice, and we're going to go through a few of them so you don't make some of the more common mistakes we see among some foreigners. Now, for this next one, you should know that Canadian trademark law was completely overhauled in 2019. And among the changes was the introduction of inherent distinctiveness as a possible objection by Canadian trademark examiners. So this is new to us, and it's new to the Trademarks Office. They're learning, we're learning. We're going to discuss some of the evolution and where we see the concept going in the future. The next one is the bane of our existence. And for any of you who have done any prosecution in Canada, it will be the bane of your existence. Canada has the most specific requirements for goods and services in the entire world. It drives everybody crazy. And so we will explain what you might expect in Canada and what you might have to do to overcome some objections that you are likely to see. Next, we're going to talk about threats by the Trademarks Office. Do you need to take those threats seriously? Well, we will let you know. Divisional applications were another introduction or another concept newly introduced with the change to our practice in 2019. We'll tell you when you might want to consider divisional refusals and how the process works. And finally, we'll talk about examination delays. Canada, if it is not the slowest trademarks office in the world, it must be among the top 2 or 3. We'll tell you what those delays look like and what you can do to expedite prosecution. Next slide, please. And so now I will turn the stage over to Nora. Go ahead, Nora.
Okay, great. Thank you, Philip. So to start, if you are a foreign representative and you filed a Madrid application on behalf of your client and you designated Canada, then you will have probably received a letter from the Canadian Trademarks Office that looks like the one on the slide. And in case you haven't had the pleasure of receiving one of these letters, I'll just give you a quick summary. So this is called a courtesy letter, and it's issued by the Canadian office to inform the foreign rep that this is the last piece of correspondence that they're going to receive from the office in respect to the Canadian designation for the entire life of the application. So the question becomes, if the Canadian office won't correspond with the foreign representative, then who will they correspond with? Well, after the courtesy letter is issued, the Canadian office will by default send all communications directly to the applicant. They will also send some, but very significantly not all communications to WIPO. So this chart shows where the Canadian office will direct correspondence for a Canadian designation. As I just mentioned, and as you can see from the right-hand column of the chart, there are several important types of communications, some of which have critical deadlines, which the office won't send to WIPO, but rather only to the applicant. What this means is that you, as the foreign representative, can't keep apprised of all updates and deadlines relating to the Canadian designation just by monitoring the WIPO website. So just to give you an example, the Canadian office will send the first provisional refusal, which we call an examiner's report to WIPO, and it'll be available on the WIPO website. But if the Canadian examiner maintains any objections and issues a subsequent report, that report won't be sent to WIPO, and it'll provide the applicant 6 months to respond. If no response is filed by the deadline, the applicant will be considered in default to prosecution. And that leads into another example that's starred there on the slide. The Canadian office won't send notices of default to WIPO. So these notices are issued by CIPO to let the applicant know that they're in default, and it'll give them 2 months to remedy the default. If the default isn't remedied by that deadline, then the application will be deemed abandoned. So the takeaway here is that if you, as the foreign representative or the applicant, want to avoid the situation where the applicant is receiving correspondence directly from CIPO, some of which is not sent to WIPO and has critical deadlines, then it's important to appoint a Canadian agent. And once the Canadian agent is appointed, the office will send all correspondence to the agent and not to the applicant. Okay, so as Philip mentioned, provisional refusals issued from the Canadian office can be confusing. So on this slide and the next slide, we've reproduced a refusal that was recently issued by the Canadian office. And I think this is a really good example of how long and confusing the refusals can be. So the first thing to note is that this refusal is 4 pages long in total. And I'll show you the last 2 pages in just a minute. The second thing to note is that if you take a look halfway down the first page, you'll see a section called Grounds for Refusal. And that section goes on to the second page, and it lists about 7 different sections of the Trademarks Act that have been cited by the office. So if you look at this at first glance, it looks like the office has raised several serious, possibly substantive objections. But in fact, the office has actually only raised one issue, and that's highlighted in the red box on the slide. And it's not even an objection. So the office here has simply asked the applicant to provide a translation of any words contained in the mark that are in a language other than English or French. As promised, here are the last 2 pages of the refusal. So we have 4 pages in total for one minor issue. So just keep in mind that the refusals you receive from the Canadian office can be confusing, they can be long, and they may look more serious than they actually are. Shifting gears a little bit. When it comes to amending a Canadian designation, there are 2 limitations that you should be aware of. First, the visual representation of the mark in the Canadian designation has to be identical to the one in the international registration. So, for example, If the IR contains a color version of the mark, like the top example on the slide, then the mark in the Canadian designation also has to be in color, and the Canadian office will take the position that color is claimed as a feature of the mark, even if the IR doesn't have a color claim. The office will not let you amend the representation in the Canadian designation to black and white. The second limitation is that the NIS class in the Canadian designation has to be identical to the one in the IR. So, for example, let's say you have an IR covering only statues in class 14 and you've designated Canada. Then during examination, the Canadian office raises their most popular objection, requiring you to further specify the term statues. Well, when you're responding to the objection, you're only going to be allowed to amend the application to include other goods in class 14. So, for example, statues of precious metal or statues of precious stones. On the other hand, if you have a nationally filed application covering the same goods, so statues in class 14, and the examiner raises the same objection, you can amend the application to include goods in other classes, as long as they don't broaden the scope of the application as filed and you pay the government fee for adding a class. So, for example, you could amend your national application to include both statues of precious metal in class 14 and statues of stone in class 19. Another thing to keep in mind is that there are certain changes, for lack of a better word, that have to be made directly through WIPO, and they can't be made through the Canadian office. Those are listed on the slide. So briefly, requests to record changes in the owner's name or address, those have to be done directly through WIPO. Second, the Canadian office won't consider any requests to amend the statement of goods or services in a Canadian designation before they issue a provisional refusal. Instead, you would have to request a limitation of the goods and services in the IR in respect of Canada directly with WIPO. And then finally, changes in ownership have to be filed directly with WIPO. And on that point, you should keep in mind that if the IR is assigned to another party, then the Canadian agent will be automatically revoked for the Canadian designation. CIPO takes the position that the Canadian agent needs to be appointed by the new owner. And with that, I will pass it back to Philip.
Thanks, Nora. Actually, I'll just add a comment relating to the last point you mentioned. So if there's any change of ownership, the Canadian agent is revoked. Fair enough. The Trademarks Office does not tell us we're revoked, which is problematic. And so sometimes some new correspondence will come in, the client will be made aware of it, and they'll say, why didn't you tell us? And we didn't tell them because we weren't told. So we brought this up with the Trademarks Office, and for reasons that are unclear, the Trademarks Office refuses to tell the Canadian agent that they've been revoked. So this is problematic for everyone, but you should just be aware of this, because often clients will file a change of name, even, which they think is innocuous, and maybe it is, but will be revoked. We won't know, and you might not know. So it's always good to tell your Canadian agent when you filed any change of name or assignment. Okay, next we will talk about a substantive issue, and this is the concept of inherent distinctiveness. As I mentioned up front, Canadian trademark law was completely overhauled in 2019. So our act was completely rewritten. We joined the Madrid Protocol, we joined Singapore, we joined NIS. So it was a very eventful time for Canada. And what it meant was, not only were all these changes new to the practitioners, but these changes were also new to the Trademarks Office. So for the first time, trademark examiners had to deal with the concept of inherent distinctiveness. And at first, it was really problematic. A huge percentage of all trademark applications received an objection that the mark was lacking in inherent distinctiveness. It didn't matter what the mark is. It's just examiners went crazy and issued this objection because they didn't understand what the concept was. Now, it has gotten better. The Trademarks Office does have a better understanding of the concept of inherent distinctiveness. But in my view, and in the view of many of my colleagues, they are still issuing the objection more often than they should. And I should go back a step and tell you that it's been a traumatic time at the Trademarks Office, especially since 2019. There's been the pandemic was problematic because for a while the examiners couldn't go in the office and it was a paper-based office, and so they got backed up. There was lots of stress. There's been significant attrition at the trademarks office, so there are not very many senior people at the trademarks office, which has made these new concepts difficult for all of the remaining examiners to learn and understand. So as I will explain, and this is my own view and not necessarily reflected the view of others, there is a lack of understanding of fundamental principles of the trademarks office, which comes out when we talk about the idea of inherent distinctiveness. Because it's new, the trademarks office is just doing what they want. There have not yet been any appeals to the federal court, so there's been no guidance from the court. And until that happens, the trademarks office will be able to make decisions just based upon their own thinking without any guidance from the court, which we think is a bit unfortunate. And we're hoping as time goes on, there'll be some court decisions to help inform the trademarks office. All right, so what is inherent distinctiveness? Well, if the trademarks office feels that the mark does not have any inherent distinctiveness, meaning that it is not inherently capable of distinguishing one party's goods or services from those of another, they will issue an objection that the mark lacks inherent distinctiveness. So let's look at some examples. If the trademark office feels that the mark is primarily merely a geographical location, such as a well-known place like London or Paris, they will raise this issue. And you will not be able to overcome it, regardless what your goods and services are. In a moment, we'll tell you what options you have when you see this objection. But this is not an objection you'll be able to simply argue around. If your trademark is a design that looks like the goods or services, you could see this objection. So for example, if you have a depiction of grapes that's not overly fanciful and you're selling wine, you could receive this objection. If your services relate to the provision of electricity and you have this lightning bolt, you could receive this objection. Names of colors. Now, this is not always a problem. And one of the issues I have in terms of the objections we're receiving from the trademarks office is sometimes the issue is black or white, but often in trademark law, as in any type of law, the issues are many shades of gray. Trademarks office doesn't like shades of gray, and so their principles, especially to the new examiners, but really to most examiners, these are the guidelines, and they're black and white, and the trademarks office just applies the guidelines without understanding the fundamental concepts. So, names of colors. If your trademark is the name of a color, white, green, blue, and you're selling something that has historically been associated with that color, the trademarks office will raise this objection. So if your trademark is white and you're selling paper, you can expect to receive this objection. If you're selling toy fire engines and your trademark is red, you can expect to receive this objection. However, if the trademark is the name of a color or something that is not normally associated with this color, we would hope that the trademarks office would not issue this objection. Laudatory terms or phrases. So these are phrases that provide praise. Wonderful, world's best, terrific, good, great. You can expect to receive this objection for all types of laudatory terms or phrases. Next slide, please. So we're continuing our list of the types of marks where you can expect to receive an objection that your mark lacks inherent distinctiveness. Surnames. And now this is an area that makes me crazy. If a mark is primarily merely a surname, the trademarks office will issue an objection. What does that mean? It means that the mark is a surname, also that it would be perceived as a surname. Now, in my view, examiners don't understand the fundamental principles behind this objection. So I think we're getting many more of these types of objections that we should. So this is how the trademarks office sees the issue. If you filed an application for something that is a surname, and if it has no other dictionary meaning, the trademarks office is likely to raise the objection and they are unlikely to withdraw. I think this is problematic. I've argued with them a few times. These are cases, I think, where the mark is a surname but would not be perceived as a surname, where an appeal to the federal court would be warranted. I'm going to talk about that a bit later. Marks that are combinations of unregisterable elements, you can expect to receive an objection. So here's an example: Alfredson's Best Carrots. So Alfredson is primarily merely a surname. Best is laudatory. It provides praise, carrots, that's what we're selling. So this is a combination of unregisterable elements. In this case, I think the Trademarks Office would be warranted to issue an objection that the mark lacks inherent distinctiveness. But I think we can all think of examples where you have combinations of unregisterable elements where the combination has some degree of inherent distinctiveness. Now, keep in mind here, the test is not the mark is distinctive. It just has to have some level of inherent distinctiveness, and you don't need much. A scintilla should be enough. And these are cases where the Trademarks Office doesn't see shades of gray, whereas in reality, this is an issue that has many shades of gray. And where the Trademarks Office refuses to withdraw objections in certain cases, it might warrant an appeal, as I will come back to in a moment. And finally, the last type of mark where you can expect to receive an objection that your mark lacks inherent distinctiveness are for what we typically call non-traditional marks. So marks that are the shapes of the goods, like a Coke bottle or Toblerone bar. Sound, color per se, taste, scent, texture. So with the change to our law in 2019, anything that functions as a trademark is theoretically registrable as a trademark. But with these types of non-traditional marks, while they are in theory registrable, you will have to prove, as I will mention in a minute, acquired distinctiveness or secondary meaning. So next slide, please. Okay, so you've received this objection. Your mark lacks inherent distinctiveness. What do you do? Well, there are two main ways to overcome the objection, and then I'm going to throw in a third way. So number one, you can argue that the objection should be withdrawn because the mark, in fact, has some level of inherent distinctiveness. So we have to go back to first principles here. What does this mean? The Trademarks Office is saying this mark is incapable of functioning to distinguish one party's goods or services without evidence of secondary meaning. Incapable. It has zero inherent distinctiveness. Often, as I mentioned, we believe that if you go back to third principles, you could say, oh, okay, we acknowledge that the mark is weak. It doesn't have much inherent distinctiveness, but it has some. And so those are the arguments you would want to file. Now, in some cases, the Trademarks Office will relent. They'll say, okay, we agree with you. It's not completely devoid of inherent distinctiveness, so we'll withdraw the objection. That happens sometimes, not very often, and in my view, not often enough. Now, in cases where the objection is warranted, or where you're unable to overcome the objection, another option is to file evidence of what we call acquired distinctiveness and what much of the rest of the world calls secondary meaning. Okay, so there are a few concepts you need to understand if you're going to file evidence of acquired distinctiveness or secondary meaning. All right, first, you don't have to file the evidence when you file the application. You only have to file it in response to a provisional refusal. The evidence has to be in the form of an affidavit. You cannot just file a letter or website. You have to provide evidence that existed prior to the filing date. Now, this is important. Any evidence after the filing date is irrelevant and will be ignored. The evidence has to relate to Canada. Any evidence of reputation outside of Canada, the Trademarks Office will say is probably irrelevant and will probably be ignored. The exception is where you can prove a large number of Canadians were exposed to the mark in other countries. It's very difficult to prove that. Most of the time, the Trademarks Office will simply ignore any evidence from outside Canada. So the evidence has to be before the filing date, has to relate to in Canada, also has to relate to the specific goods and services in your application. So this is where I get a little bit worked up. So in the old days, if you go back about 5 years, let's say you have a mark and you could prove secondary meaning in association with pens. And now you're filing an application to register the same mark in association with pencils. In the old days, maybe 5 years or 10 years ago, the Trademarks Office would say, okay, we recognize your mark is well known in association with pens. We recognize pens and pencils are usually associated in people's minds as being connected. Therefore, we will be willing to conclude that you don't need to file evidence specifically relating to pencils. We're willing to allow you to register your mark in association with pencils, even though you haven't filed any evidence specifically directed to pencils. The view now is different. The Trademarks Office requires evidence of the specific goods and services in your application. It doesn't matter how famous the mark is generally. It doesn't matter how famous the mark is in association with other goods. If you don't prove secondary meaning in association with the specific goods and services in your application, you will not get a registration. In my view, this is wrong, and it misunderstands the basic concepts of secondary meaning. In other words, will people assume that this is a trademark? Once again, we have no case law because none of these cases have been appealed. So this leads me to the third option of which people can think about when they receive this objection, and that is to file an appeal with the federal court. So in my view, one of the biggest frustrations right now is that the Trademarks Office just relies on its own principles. There's no guidance from the federal court because none of these issues have been appealed to the federal court. As I mentioned before, to the Trademarks Office and virtually every examiner, they think these issues are black and white. They have a series of guidelines. The issues either fall within the guidelines or they don't. And once they've made up their mind, you can't argue with them because in my view, many examiners don't understand the basic principles. So what needs to happen is some applicants need to appeal these decisions to the federal court so we can get guidance from the federal court, and then the Trademarks Office will be required to follow the guidance from the federal court. So we're all very frustrated right now with these types of objections. I think we will be less frustrated if some applicants decide to go to the federal court. That's my editorial comment. Once again, my views don't necessarily reflect the views of the entire Canadian profession, but I think they do reflect the views of a majority of the profession. Next slide, please. Okay, moving on. This is an area that, although I get frustrated by the concept of inherent distinctiveness, this is the concept that frustrates most people who come into Canada and want to register their marks. If you're dealing with any trademark applications relating to Canada, you will have seen this objection. The Trademarks Office will have objected that some or all of the goods and services are not in ordinary commercial terms and are not sufficiently specific. You can really ignore the concept of ordinary commercial terms. This objection is really the mark is not sufficiently specific. And what the Trademarks Office wants to know, and this is different from most countries in the world, is to assess confusion in Canada, you have to know the target market. And if the Trademarks Office cannot figure out the target market from your description of goods and services, they will require more specificity so they can figure out the target market. So that's usually the reason the objection is being raised. I'm sure most of you have dealt with applications in the United States, and most of you think the requirements in the States are very specific. Canada's requirements are even more specific than the requirements in the States. Often our clients will say, well, this is how we amended the application in the States, just apply those same amendments in Canada. And while we're happy to take your instructions, often that won't be enough. Don't assume that simply because the description satisfied the USPTO, that it will satisfy the Canadian Trademarks Office. We've become quite expert in dealing with these objections, and we can handle them fairly efficiently, probably a lot more efficiently than you or your clients can, but you're certainly welcome to do this analysis yourself. And so the Canadian Trademarks Office has an ongoing publication which they update on an ongoing basis. It's called the Goods and Services Manual. And this has a list of I think it's somewhat more than 100,000 terms right now. So if you file any descriptions from the manual, you will not receive an objection. But more importantly, you will often be filing descriptions that won't appear exactly as you would like from the manual. But the manual will give you a sense as to the level of specificity required for your terms. So even if the term you want doesn't appear in the manual, you can look up and see something that's similar. And if you use a similar level of specificity, it should be accepted by the Trademarks Office. So once again, you're welcome to go to this site and you can perhaps make this assessment yourself. But if you find a Canadian agent, they're probably more likely to do this more efficiently and probably have a higher success rate in coming up with descriptions that will be acceptable. Now you'll see at the bottom of your screen that we have a tip. This tip doesn't apply to everybody or every situation, but we just want to bring this to your attention. Some clients, when they file an application, they'll say, well, we want a description that will be accepted by the Trademarks Office. And that's certainly reasonable. You don't want an unnecessary provisional refusal. But you need to keep in mind a few things. And one of the important considerations is that these tests about the level of specificity that's acceptable, it's changing all the time. And so a term that's acceptable today might not be acceptable in a year, and vice versa. The other thing you need to know, and we'll be coming to this at the end of the talk, is that examination delays in Canada are very long. For a provisional, for a Madrid designation, the requirement under the protocol is that all applications have to be examined within 18 months. So the Trademarks Office will examine your application just under 18 months. If you file a response, it's going to take the office now up to a year to review your response. So there's a very long delay. And in that time, the requirements of the Trademarks Office could change. So what we want clients to avoid is unnecessarily narrowing the descriptions of goods and services. So while we're happy to discuss with you how narrow your descriptions have to be not to get a provisional refusal, in some cases, clients want descriptions as broad as possible. And if you narrow at the beginning, you might be providing descriptions that wouldn't receive an objection. So you're playing a guessing game. So we don't want to discourage clients from narrowing early, but just keep in mind that you might be getting descriptions that are narrower than they have to be. So sometimes it might be more beneficial to the client to wait and see which descriptions provoke an objection rather than proactively narrowing your description. So it's really a case-by-case analysis where you'd have to figure out what is the most benefit to the client. Next slide, please. Final refusals. So this is interesting. So if you go back not many years ago, the Trademarks Office virtually never refused an application. And refusing an application means we're done with your application. It's dead. Unless you want to appeal the decision to the federal court, your application is dead. So they virtually never issued any final refusals before, about 3 or 4 years ago. But then the Trademarks Office, they're in a state of crisis. As I mentioned, the delays are tremendous. They can't keep up with the backlog. They wanted to know what they could do to reduce the backlog. And so they decided that they would start refusing applications. And they warned the professions. They told us all, we are going to start rejecting your applications. And what we're going to do is if we see that you're trying to delay, or if you're issuing a response to a second or subsequent provisional refusal, and your arguments are no different than what you filed before, we're going to refuse your application. But we're not going to be completely unfair to you. We're going to warn you first. And so for those of you who have been practicing or seeing provisional refusals from Canada, you're going to start to see what we have here encircled in red. I need to put on my glasses here. And this says, you are further advised that this application may be refused if your next response does not overcome all objections. Okay, so now they've warned us, and now they've warned you that your application could be refused. And so when we first were told by the Trademarks Office that this could happen, and they said, we're going to do this. And then we started seeing this, we would warn our clients, and then our clients would get nervous, and then we would get nervous. And so should you be worried about these threats? Well, so in 2022, the Trademarks Office said, we are taking this seriously. And in fact, we have increased the number of refusals 400% over the last year. So now if you dig into the numbers, you can see where this 400% comes from. 2021, they refused 3 applications out of, and I'm not sure how many are pending. It's several 100,000, I believe, applications that are pending. So they refused 3 of several 100,000 applications. I'm not sure what that percentage is, but it's tiny. So, but I told you it increased 400% in 2022. So what does that represent? Well, the number of refusals went from 3 to 13. So that's a 400% increase. 13 out of several 100,000 pending applications is still negligible. So what are they refusing? Well, they're refusing applications where the applicant is clearly just trying to delay, and they're going to refuse applications where the response is where it's clear that the applicant made no effort in finding new arguments. So if you are working with a competent Canadian agent, this will not happen. So I canvassed all of my colleagues in the firm. Not a single one has received a refusal. So this is not something you have to worry about. You should keep it in the back of your mind. Maybe if anybody from the Trademarks Office is listening to me, they would want to punish me. I'm not sure. But I think the likelihood that any application being refused that's being handled by a competent Canadian agent is very low. So you shouldn't completely ignore the threat, but it's not a threat that you need to lose sleep over. Okay, I think next slide, please. Okay, so divisional applications. So this was another change from the overhaul of the Canadian Trademarks Act in 2019. So before 2019, it was not possible to divide a Canadian trademark application. With the change to our law in 2019, it is now possible to divide applications. So how do you do it? When would you want to do it? Well, interestingly, there's no fee. So if you have 1,000 goods in your application and you wanted to file a divisional trademark applications, you can do that, and it's free from the government perspective. Now, your agent is going to charge you whatever their fee is times 1,000, but there's no government fee, which is interesting because it's a lot of work for them. So there's no government fee to divide. When would you want to divide? Well, there are a few cases. So let's say your application has many goods and services, and you have a serious substantive objection to a subset, and your client, or if you're the applicant, you want to obtain a registration as soon as possible. What you can do is you could divide out the problematic goods or services, and then you have a divisional to the non-problematic goods or services, and that divisional application will proceed to registration quickly. So in a case where it's important to get a registration quickly, which you could do, for example, if you want to sue somebody, or you want to get you want to get a registration so you don't have to translate your mark in Quebec, or you want a .ca domain name. There are many reasons why you might want to obtain a registration quickly. You can do that by dividing out. So that could be useful in prosecution. It can also be a useful tool in oppositions. It could be that your mark has been opposed by somebody, but the opponent might only care about a subset of your goods and services. So once again, you can divide out the problematic goods from the non-problematic goods. The divisional with the non-problematic goods can sail through to registration. You have a registration, and then you're only delaying the application with the problematic goods or services. And if you're lucky enough or skilled enough to obtain 2 registrations from the applications you've divided, you can merge them again once they've been registered. And so that could be beneficial if you don't want to maintain 2 separate registrations, which will double the renewal fees, and will also add to the logistical issues you have and the number of marks under your management. Okay, next slide, please. Okay, so now we're going to turn the stage back to Nora. Go ahead, Nora.
Thanks, Phil. So as Philip mentioned, the Canadian Trademarks Office could either be the slowest office in the world or definitely somewhere close to it. The delays are significant. In terms of how bad they actually are, well, currently, the delay from filing to examination for nationally filed applications that include goods or services which aren't from the pre-approved list in the manual is a staggering 53 months. So unfortunately, that's well over 4 years. For Madrid designations, we're looking at just under 18 months from the time the Canadian office is notified of the designation to examination. But I think it's worth noting again, as Philip may have already mentioned, that subsequent examination for Madrid designations is much slower than for nationally filed applications. But that being said, it's not all bad news. So the Canadian Trademarks Office is working very hard to reduce the delays, and it's pursuing several initiatives to improve timeliness and examination. Just a few of the examples are listed there on the slide. So the office is increasing capacity by hiring and training more examiners. They have also been revamping examiners' reports. So the reports are going to be simplified. They're going to limit the use of case law, and they're going to give fewer suggestions for acceptable goods and services when they raise a specificity objection. They're also fast tracking or accelerating nationally filed applications that include only goods and services from the pre-approved list in the manual. So you'll see on the right side of the slide there that the time from filing to examination for those applications is hovering at around 20 months, which is obviously much better than 53. And then finally, the office has announced that it is going to start, or sorry, that it started back in 2020 and 2021, considering requests for expedited examination. So just on that last point, as I just mentioned, expedited examination has only become available again in Canada fairly recently. Before that, for more than a decade, the office took the position that if you examine applications out of order, then that creates a favored position at the expense of other applicants. But because of how significant the delays have gotten, the office announced that it would start accepting requests. So what do you need to do in order for your request to be granted? Well, you have to file an affidavit or a statutory declaration establishing that you meet one or more specific criteria. The slide here lists the 3 criteria that we see come up most often. The first there is that a court action is expected or underway in Canada with respect to the mark in association with the goods and services in your application. It's worth emphasizing there that the litigation or court action doesn't have to be underway yet. It's sufficient if you're contemplating it. The second is that the applicant is in the process of combating counterfeit products at the Canadian border with respect to the mark. An example of a suitable reason there might be that the applicant is aware of counterfeit products that bear the mark that are being imported into Canada, and it needs a registration to record its rights with the CBSA or the Canadian Border Services Agency, which will only record registered marks. The final criteria on the screen is that the applicant needs its registration to protect its rights from being severely disadvantaged in online marketplaces. So an example of this one might be that the applicant has identified a sale of an infringing product on Amazon.ca, and it needs a registration to enroll in the Amazon brand registry. Now, in terms of timeline, once you've filed your request, the request is likely going to be examined in about a week, or at least that's what we've been seeing. And then if the request is granted, examination should take place about a week later. And with that, I'll turn it back over to you, Philip. Oh.
Thanks, Nora. So this is our final substantive slide, and so I'm gonna. Well, we have some questions coming in. So once again, feel free to ask questions at any time, and after we deal with this slide, we will answer all your questions. At least we'll do our best. So now we're gonna give you some tips that you should consider when designating Canada. Most of these we have discussed at least to some extent. Okay. So this is one I just mentioned. So consider filing broadly and only narrow goods and services if CPO objects. So once again, that's the balancing of whether or not you want to do your best to overcome a provisional refusal as compared to risking unduly narrowing the descriptions of goods and services in your application. I think that's probably a discussion best had with your Canadian agent, because there are pros and cons of both. And there's some types of goods and services where it's quite easy to describe in a way that would satisfy the office. And there are other types of goods and services, especially if it deals with new types of technology or software, where it's sometimes difficult to determine if a particular description will be accepted. Tip number 2, appoint a Canadian agent. So if you are the applicant and you're happy to deal with all correspondence from the Trademarks Office, then by all means, continue to receive those, and you might be less inclined to appoint a Canadian agent. But if you are a foreign representative, you will not receive any correspondence from the Trademarks Office directly. It will only go to your client unless you appoint a Canadian agent. If you do not trust your client to send you all relevant correspondence, then it's really important to appoint a Canadian agent. And once again, there are 2 cases where it's essential that you have a Canadian agent if you're unsure if the applicant will tell you about all correspondence. Number 1, that's for a second or subsequent provisional refusal. Those documents are not sent to WIPO. So unless if you as a foreign agent will not be informed of a second or subsequent provisional refusal, you will also not be informed of a notice of default. These documents are not a WIPO. So if it's possible that either of those documents will issue, it's quite important to have appointed a Canadian agent. Consider whether you're eligible for expedited prosecution. As Nora told you, delays in Canada are overwhelmingly long. If it's important to get a registration quickly, or you just want a faster registration, consider whether or not any of the criteria that Nora just discussed would apply to your case. And in those cases where they do apply, you can get examination almost immediately. And understand if your application will provoke an objection that your mark lacks inherent distinctiveness. If it does, and your local agent doesn't think you'll be able to overcome the objection, maybe you want to avoid the time and expense of receiving a provisional refusal. Maybe you want to abandon your application now. Or if you know that you will require evidence of secondary meaning, you might want to begin preparing that evidence now, because it can be very time consuming to do it later on. In any event, it's a good idea to know ahead of time whether or not your application has any hope of success without evidence of secondary meaning, so you can have a discussion with your client as to how they want to proceed. This last one is file comprehensive arguments in response to objections. So there are two reasons you might want to do this. One is if you received a threat from the Canadian Trademarks Office that they might refuse your application if the next response does not overcome the objection. So that you might want to do it in that case, although, as I said, you're very unlikely to have your application refused unless you're really just repeating verbatim the arguments you filed before, or unless you're clearly just delaying. The main reason, though, why it's important to file comprehensive arguments in response to an objection, and we see this from time to time, the client will ask us, how much is it going to cost to file a comprehensive response? And we'll say it's going to cost X. And then they say, well, can't you just file a quick and dirty response for a fraction of X? And we can do that. The risk you're taking, though, is that the quick and dirty response might not satisfy the examiner, whereas the comprehensive response would have. Now, in that case, you will get a subsequent provisional refusal because, as I said, the likelihood of you getting an actual final refusal rejection is close to zero. The problem is, once you've received a second or subsequent provisional refusal on the same grounds, the Trademarks Office has dug its heels in. Historically and statistically, once you've received a maintaining objection, the likelihood of convincing the office at that point to reconsider the objection is very small. So you want to put your best foot forward. Even if you have a better argument the second time, they can be very close-minded. And often when they've maintained the same objection, it's very hard for them to reconsider the issue with an objective point of view. Okay, and with that, we can go to the last slide, which is our invitation for you to ask questions. So we do have a number of questions here. And so I'm going to try and direct it to either Nora or me as appropriate. This first question, I'm not sure who would be better able to answer it. So I will read the question. I will give my best answer, and then Nora can jump in if she has any further input. So here's the question. How often are you recommending to local clients to file an IR, an international registration? And that's an international registration, is the filing directly in a particular country. Is there an advisable cutoff, such as if you are filing in 4 foreign countries, filing an IR is worthwhile from a cost perspective? All right, so this is a hard question. And it's hard to do in the abstract because the filing fees are different in every country, number one. Number two, and this is kind of an interesting point. So if you come into Canada, either nationally or through an IR, your application will be treated exactly the same. Although I don't have direct experience of this happening, I've heard many people complain that in some countries, applications will be treated differently if you use the national route as opposed to the Madrid route. So in those countries, if you're worried that an IRR will be treated less favorably, you might want to take the national route. As I say, I don't have any direct experience with that. But I think with this question, we're normally talking about cost. When is it more cost effective to use the IR route as opposed to nationally? Certainly, if you're going to file one application, you want to file nationally. Probably don't want to use the IR route. If you're filing 2, I think most people would probably file nationally. If you're filing 3 or more, most people will probably tell you to use the IR route. If in doubt, you can do calculation. It's pretty easy to figure what the costs will be, assuming you don't need any advice to do the 2 routes. And if you do the national route in most countries, you'll have to hire a local agent so you can get quotes and do the comparison. But I think most people will tell you 3 is probably the cutoff for most people, but in some cases it will be 2. Feel free to ask us to do the analysis ourselves, and we'll be happy to do that. I don't know, Nora, do you have any further insight on that question?
No, I think you answered it.
Okay, perfect. Okay, this next question is directed to Nora. Can a foreign representative file a response to a provisional refusal?
It's a good question. Thanks, Philip. Unfortunately, no. So any correspondence filed by the foreign WIPO representative won't be considered a proper response by the Canadian office. So if you do file a response to a provisional refusal, the Canadian Trademarks Office won't consider it a proper response, and you will be in default of prosecution if you miss that deadline. And then unfortunately, if there's no Canadian agent, you also won't receive the notice of default telling you that you're in default.
Okay, thanks, Nora. Next question I will handle. Excuse me. For evidence of acquired distinctiveness or secondary meaning, is evidence of 5 years of use in Canada sufficient? So this is a good question, because it's my understanding that in some countries, if you're filing evidence of secondary meaning and you can prove that you have 5 years of continuous use up to the relevant date, the mark will be deemed to have secondary meaning. That is not the case in Canada. There is no number of years of use where the office will say, okay, we're going to deem that sufficient to constitute secondary meaning. Every case is considered separately on its facts. There's no minimum or maximum number of years you have to prove use. You could have 30 years of use, but if the Trademarks Office determines that that use is de minimis, or maybe that use was of a generic use and was not trademark use, they're going to say that's not sufficient. So there's no minimum number of years that's going to be sufficient to automatically convince the office to allow your mark to be registered in spite of a descriptiveness or distinctiveness objection. Okay, next question. This is for Nora. If a change of ownership is filed with WIPO, will the Canadian agent be advised that they have automatically been revoked? I think I answered this, but I'm going to let you answer in your words.
I think you did. So I think you already mentioned that the Canadian agent will not be advised. So I think the best practice there will be to let your agent know if you're planning on filing a chain of ownership request with WIPO, and then let them know if they should reappoint themselves.
Okay, thanks, Nora. So this next question, I'm not sure who would be best to answer this one. I think I'll take a shot at it and you can correct me. So the next question, has CIPO been receptive of transformation applications? Are there any quirks to keep in mind when filing a transformation application? So you have a basic, before you file your international registration, you have your basic application that you're relying on. So you have a home country application or registration. You filed nationally in your home country typically. Then you file an international registration and you designate other countries. You get registrations in those countries. If your basic application is canceled within 5 years, all of your other registrations are canceled. What you can do is you can transform your international rights into national rights through a transformation application. And so the question is, has CIPO been receptive? Well, they have to. It's the law. So if you file a proper request, they will transform it. Now you have to make sure there's certain information you have to include in your request, and if it's all included, it will be transformed into a national application. If you miss some important information and there's a deadline, I think it's 3 months from notification. If you miss that deadline, you're too late. It doesn't matter what you say. And what can happen is you can miss some required information in your transformation application. Canadian office might not notice by the deadline. And if they only notice it after the deadline, you cannot get a retroactive extension. Your request will die. So the Canadian office is receptive. They will transform it, but you have to make sure you do everything you need to do in time. I don't know if you have anything you want to add, Nora.
No, I was only going to add that there's no extension. I believe there's no extension of time possible of that 3-month deadline. That's
Right.
all.
Yeah, so take that deadline seriously. Okay, next question is, I think this is for me. You mentioned that for evidence of distinctiveness, sales and advertising data must be broken down by province. So I can't remember if I did say that, but whoever wrote this question is that's true. And so this is a big frustration we get from lots of clients. Foreigners will have sales data and they might have information showing their reputation. Maybe they've spent $1 billion in marketing and advertising over the year. What the Trademarks Office will say is that's nice, but that's not enough. You need to break it down by province and territory. So we have 10 provinces and 3 territories in Canada, and they want you to break it down. And so clients are really upset by this because I don't think there's any other country in the world where you have to do this. And so a lot of clients will say, okay, so we have this sales data by Canada, but we don't have it broken down by province. It'll take us, and even if we could, it would take us too much time and resources, which we don't have. And then we say, well, you have to do it. Otherwise, the Trademarks Office will not consider your evidence. And so there are ways around it. So for example, if you can say, all right, we only have sales in Quebec, Ontario, and British Columbia, and based on our experience, it seems like the sales probably were relatively equally broken up. And similarly, our advertising dollars were probably fairly equally broken up. And so we can put that in an affidavit. We say, you know, we've worked in Canada for all these years, that our sales tend to fall in our total sales, therefore we'll divide by 3. These are our approximate sales per province. So, and you do the same analysis for the advertising marketing. The Trademarks Office is likely to accept that information, even though it's not based on a hard data. If you can back it up based on the experience of the person swearing to the affidavit, they're likely to accept those figures. So keep in mind, figures do have to be broken down by province and territory, even though it's obnoxious and even though you might not have those exact figures. Okay, let's see. The next question is for Nora. If your request for expedited examination is rejected, can you try again?
Thanks, Phil. Yes. So if the office rejects the request, they will issue you a written letter. And in the letter, they'll tell you what deficiencies there were in your request. And then you have the opportunity to fix them and file it again. So it's also worth noting that there's no government fee for requesting expedited examination. So you could keep refiling the requests. I think the only cost issue there would it be, I guess, if you're using an agent and you keep refiling, well, obviously there's going to be higher fees there.
Maybe they'll get expedited prosecution just so they don't have to see your next request. Okay, the next question is for me. So I talked about the office threatens to refuse applications, but they don't refuse very many. And so the question is, what are the options if your trademark application is refused? So this will happen. You get an objection, you file a response, then you get a letter from the office saying, if your next response doesn't overcome the objection, we might refuse your application. As I said, that's very unlikely, but it could happen. You file your next response. The office thinks it's not a bona fide response, so then they refuse your application. What happens then? Well, then you have 2 months to appeal it. That's your only option. The Trademarks Office takes the position that it has no more jurisdiction to hear from you. So they won't consider anything further you say, but you can file an appeal to the federal court, and that's your one and only option. And so it looks like we're at the end of our time. If there are any other questions that you have, feel free to let us know. You can I'm not sure that we'll see any further Q&A questions from Zoom, but feel free to email us directly. We're happy to answer your questions, or you can call us. We're happy to talk to you as well. We've enjoyed doing this. We both hope you have as well. And thanks very much for joining in. Enjoy the rest of your day. Bye.